Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning. It is Saturday, October 14th, 2023. This is Morning Cannolis on the broadcast stations of Civic Media throughout the state of Wisconsin. This is our 67th broadcast coming to you this morning from downtown Waukesha. I am joined in the studios this morning, as always, by my fantastic producer, Anya, who's with me today to take your calls, your questions, your comments, perspectives. That number, of course, 844-967-2789. 844-967-2789. Also taking your comments and questions, perspectives by text, by messages to Anya and me. Go to Civic Media online, find the broadcast station through which you hear this show, and pull down our menu, the Morning Cannolis menu, and send us some information about thoughts that you have this morning on the many topics we're going to be discussing. This is, as always, our weekly review, our analysis, our discussion of those most important news stories in the areas of law and government and the aspiration for justice in America, also occasionally, including this morning, overseas as well. We always ask three questions. We always ask, what do we know? What do we know about the facts going on out there? What happened? Why are those things important? Why are they relevant? Why are they significant to our lives, our livelihoods here in the United States and as citizens of the world? And what, if anything, can we and should we be doing in response to those important things happening in our lives? What actions, what responses, what answers should we offer up to those events and circumstances in our lives? Those questions, again, especially important this morning as we undertake a very aggressive but achievable syllabus. We're going to begin by chatting this morning a bit about overseas, and specifically the conflict, the war going on right now in the Middle East, certainly mindful as well of the war going on in Ukraine and other places around our planet. And after that, we're going to return to other rule of law issues, those including revisiting some issues we talked about at the conclusion of our program last Saturday. Got many wonderful calls, comments, questions from you in the 6 or 7 days since our discussion about the 14th Amendment and also about false electors here in the state of Wisconsin. I'm going to respond to some of those, try to codify what we chatted about a little bit last week, and then talk about some additional issues related to those two important rule of law issues. Again, the 14th Amendment, Section 3, whether or not it prevents a certain present candidate for the presidency of the United States of America from serving in that capacity and even appearing on ballots around the states of this country. And then also chatting again about false electors. What is the status of false electors around the country, including Michigan, including in Fulton County, Georgia, and right here in Wisconsin? We're going to talk about that once again, and then various updates on a number of different trials, 4 different events, 4 different judicial proceedings, also involving our former president in various states and various jurisdictions around the country. We're going to chat about 2 recent cases, the initiation of new charges against 2 members of our United States Congress just this past year, and what that means not only for them, of course, to the rule of law, in addition, but also what that means in terms of the future of the operation of the Congress and the attempts in our United States Congress to address the many issues we have pending before us in our nation, the areas of immigration and violence involving guns, the areas of healthcare and all sorts of things out there that should be on the agenda of our Congress. What do those kinds of things do? The charging of sitting members of the Congress, one in the Senate, one in the House of Representatives. Why is it important to do that? And what lessons should we take from those particular charges coming out just this week, again, from the U.S. Department of Justice? And then in our second principal hour this morning, as always, we're going to spend some time talking about the United States Supreme Court. As in previous weeks of this month, the United States Supreme Court was active just this past week in hearing arguments on 3 very important cases, one in particular having to do, yes, that's right, with voting rights, coming out of South Carolina, a question of gerrymandering and politics in the Supreme Court wrestling with whether or not whether or not those kinds of things are justiciable, whether or not political considerations and racial considerations mixed up together in determinations made by the the South Carolina legislature should in fact be the subject of a decision coming out of the Supreme Court in June. Alabama case also, as we know, pending. Other cases out there likewise impacting not only the implications, the application of the Voting Rights Act, but also voting for Americans across our nation. An aggressive but achievable agenda this morning. Thank you once again for joining me this hour and hopefully also next as we talk about these and many other issues before us today. I'll also indicate before we get started this morning substantively that there is an important program note, which is that next Saturday, the 21st of October, I'm going to be broadcasting again live from the Civic Media Studios in Madison at 3535 University Avenue, right there in downtown Madison. A first experience for me broadcasting from that particular location. Excited to do it. I know we've got many, many listeners from the Madison area, many listeners throughout the state of Wisconsin. Excited to be coming to you from that specific location next Saturday. Again, as always, the format will be the same. Reviewing the important questions and issues and news stories in law, government, and justice in America. But as always, taking your questions, your comments at that time as we do this morning. Once again, that phone number, 844-967-2789. Also text us on the Civic Media app, Civic Media online folders, and get your comments and questions to us throughout this morning and also future broadcasts. Let me begin by talking about the issue which is on all of our minds this morning, and that is war on our planet. As I indicated, we know well that the war in Ukraine continues. The wars in other places of conflict throughout our globe, throughout the nations of our communities, overseas, and right now, especially focused upon the Middle East and the war that is underway, having begun last week, just about at the same time that we were on the air, involving Hamas and the State of Israel. It is a little after 5 o'clock on the evening on Saturday in Israel, in Gaza, in the Palestinian area right now in the Middle East. What do we know about what's happening just this morning? Well, we know that there was some information provided earlier in the day there in Israel and in Gaza that arrangements have been made for Americans to go to what's called the Rafah border, bordering on the nation of Egypt. And yes, that's where Gaza is. It has a border not only, of course, with Israel, but also with the country of Egypt. And there were plans made to permit Americans to cross that border, presumably to safety, into the Egyptian nation. Unclear as of a couple of hours ago whether that was successful or not. But the Rafah border, again, focusing on this huge issue related to a very small geographic area. Gaza, probably about the size of the city of Philadelphia, a very small area, obviously, millions of people in that small area, which is also a part of the humanitarian crisis caused by the conflict now underway there. We also know that there are Israeli tanks right now who are at the border, the northern border of Gaza, likely going to be rolling in sometime soon. This is going to be a full-scale war. It already is. More people, in addition to the thousands of people, Israelis and Palestinians who have already lost their lives in this conflict, more people are going to die. Huge numbers of casualties, as we know, huge numbers of injuries as a result of this displacement of people and human tragedy, as we often discuss. In my own experience, having spent 2 years in the nation, the Republic of Iraq, 2006-2008, I was a part of a contingent sent there by the U.S. Department of Justice, the U.S. Department of State, and yes, indeed, the U.S. Department of Defense, all of us combined in an attempt to try to establish the rule of law in the wake of the Saddam Hussein leadership and autocracy there. That happening in 2006 to 2008. Among the reasons that I went there was to get a sense of war in our times. And certainly it was very instructive to me. I'm reminded once again of it when I see images coming out of Gaza, coming out of Israel, coming out of Ukraine, other places in the face of our planet also involved in horrific conflict. Conflict by its very nature of this sort, war by its very nature, is the ultimate form of destruction. When I was in Iraq, we often spent time attempting to reestablish the basic trappings of civilization there in the midst of a war going on, in the midst of this very destruction that affects not only lives of people, first and foremost, their livelihoods, huge numbers of injuries, not just to military troops there at the time, coalition forces, Iraqi forces, and the forces who would stop the progress moving forward in the rule of law area, but also, of course, destruction of the fundamental trappings of the way in which people live. We're talking about basic access to medical care, health care, access to education, training, and growth, access to the culture, obviously, as well, access to all those things that we envision when we think about commerce and transportation, the ways in which we deal with our lives on a daily basis, the ways in which we deal with each other. All of those not only stopped, but affirmatively destroyed by war. This is plainly advocacy, which I know all of you embrace, for some sort of negotiated resolution to what is admittedly a crisis, an unresolved crisis for well over 70 years now. The problems have gone on for a very, very long period of time. Proposals for things like a two-state solution continue to be proposed during the course of discussions both here in the United States and certainly around the world. Today's violence in the Middle East, the war that is now underway, likely to even get worse in the next 24 to 48 hours, calls upon us all once again to figure out a way to identify the mechanisms, as difficult and challenging as they are, to try to resolve this, to ensure that we don't have even more losses of life and that the basic trappings of the rule of law can be promoted. War is the ultimate destruction of the rule of law and justice and notions of government. That was one of the great lessons I pulled from my time in Iraq, the 2 years, 2006 to 2008. It is the destruction of life, the trappings of the prosperity that we think about when it comes to the human existence that we all enjoy and should be pursuing on a regular basis. What was happening, obviously, in Iraq is different from what's going on in Israel and in other places around our country, but that fundamental notion, once again, that war is the ultimate destructive force when it comes to establishing and maintaining rule of law, something we need to keep in mind as we go ahead this morning. When we come back right after this first break, we're going to talk more about a couple of issues we chatted about last week, including here in America, the application of Section 3 of the 14th Amendment, and also fake electors right here on Morning Cannolis. And we are back here on Morning Cannolis. Thank you for joining me this morning in our discussion of some major stories this past week and pending in the contemporary consideration of what's going on in courts and in judicial proceedings around our nation. Let's get right into some of those. Last week, we began our discussion of the 14th Amendment, this issue that many of you have followed up with me on this past week. The 14th Amendment, Section 3. We don't always think of the 14th Amendment as being the focus of qualifications to run for office in America. We know that the 14th Amendment, Section 1, passed in the wake of the Civil War, July 9th of 1868, ratified by a sufficient number of states, basically says that there will be no one who was born or naturalized in the United States subject to the jurisdiction of our nation or any place in the United States of America shall be denied the privileges and immunities of citizenship and deprived of any life, liberty, or property without due process of law. And likewise, the 14th Amendment, Section 1, prohibits denial to any person within the jurisdiction of equal protection of the laws. That fundamental affirmation that the recently emancipated slaves at that period of time are entitled to all the rights and the privileges of citizenship, that's Section 1 of Amendment 14 of the United States Constitution. Section 3, again, often forgotten in our history. Why? Because it applied specifically to this time period after the Civil War, when you could identify, Abraham Lincoln could, and frankly, others in our government could identify with particularity the folks who were involved in the insurrection. Abraham Lincoln, of course, died before he saw the actual implementation of the 14th Amendment, but his contemplation was that the slaves would in fact not only be emancipated, restored to, brought to full citizenship in our nation, and then also that those people who had engaged in the insurrection, which was and remains the Civil War in the United States of America, would not be permitted to serve in positions of responsibility and authority as a result of the insurrection in which they had engaged. Abraham Lincoln also anticipated that, again, even though the 14th Amendment not ratified until after his assassination. What does Section 3 of Amendment 14 of the Constitution say? It says this: "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as member of Congress or as an officer of the United States," that's the all-important language here, "or as a member of any state legislature, or as an executive or judicial officer of any state to support the Constitution of the United States, any person who's done that, taken that oath of office, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof." That's the prohibition of Section 3 of Amendment 14 to the United States Constitution, prohibiting someone who's taken that oath to the Constitution of the United States of America, who is also then engaged in insurrection or rebellion against the same, prohibited from serving in those official capacities plainly applicable to federal law enforcement, federal executive positions, federal legislative positions, federal judicial positions as well, involving the work and the activities of the United States of America. Well, why is that important? Well, again, as we have began to chat last week, soliciting and receiving many of your questions and comments in follow-up to that discussion. What does the 14th Amendment mean today? Well, an awful lot of focus on whether or not Donald Trump, the former president of the United States of America, should be prohibited from not only serving as the president of the United States of America, if indeed he's elected to that position in 2024, about 13 months or so from now, but also even prevented from being on the ballot in the various states around the nation in which he plainly would be appearing, absent some change in the law, absent some decision by state officials to keep him off the ballot. And that's where it gets to the 14th Amendment. An awful lot of people out there, including some very learned academics, we talked about them last broadcast, who proposed that the 14th Amendment is self-executing, that by its very nature, just as it was in the wake of the Civil War, everyone knew who the insurrectionists were, and they were prevented then from serving in any official capacity. Their argument is that today, in 2023, 2024 as well, the 14th Amendment remains self-executing by its very nature. By its very nature, cannot have anyone serving in those capacities, in federal capacities of official responsibility, cannot be serving in the roles in any federal position around the country, cannot be appearing on any ballots. The 14th Amendment, by virtue of its very language, self-executing, keeping people off the ballot if they have previously engaged in the insurrection about which the 14th Amendment speaks. And so what's been going on around the country, as we chatted last time, many of you called to follow up on the specifics and asking for information. Lawsuits are being filed right now, and they fall generally into a major category and then a second category, which we'll also talk about. Some of you asked about this in particular. Many lawsuits in various states around the nation, New Hampshire, other places, Minnesota, Michigan, and Colorado in particular. Many cases now being filed seeking what's called declaratory judgment, seeking a declaratory judgment that Donald Trump should not be permitted to show up on the ballots for the presidency in those states. A declaration is what the request is, that when it comes to creating those ballots in those states, and presumably others where these cases are also pending, Donald Trump's name should not appear as a candidate for the presidency because, the argument goes, he engaged in insurrection and therefore should not appear on those ballots in violation of the prohibitions of set forth in the 14th Amendment, preventing him from being on those ballots. So what has happened? Those cases are proceeding apace. And in particular, just this past week in Colorado, in Colorado, we had a particularly important decision made by a judge there. A group of Colorado voters there, they're backed by a fairly liberal watchdog group, are arguing again the 14th Amendment bars Donald Trump from Colorado's ballot, keeps him off the ballot in that state. And the amendment, of course, as I indicated, prohibits people from holding office in Colorado and other places around the country if they've engaged in this insurrection or rebellion against the United States of America. Now, Donald Trump and his lawyers in these various jurisdictions, including in Colorado, have said that the lawsuit is an attempt to infringe on his First Amendment rights and prohibit him from appearing, obviously, on the ballots, from serving in this capacity, and from pursuing his interest in becoming the next president of the United States of America. They sought to dismiss the claim under Colorado law that aims to protect people from frivolous lawsuits and for exercising that right. When we come back, I'll tell you what happened in... We are back here at Morning Cannolis, spending some time in response to your questions and comments this past week about our introductory comments last week about the 14th Amendment, and then also going to be chatting in just a few moments about fake electors in our nation and here in the state of Wisconsin. Right before the break, talking about litigation that has been initiated in many states around the nation to invoke the 14th Amendment prohibition of people who engaged in insurrectionist activity from serving in official capacities in the federal government. A lawsuit pending in the state of Colorado, some significant action this past week. This action, obviously opposed by the former president, Donald Trump, and his lawyers. But this past week, without ruling on the merits of the case in particular before her, Denver District Court Judge Sarah Wallace ruled just on Wednesday. And then she said this: in short, it is in the public's interest that only qualified and faithful candidates be allowed to seek public office, and that an exemption to the law, and she's talking about this SLAPP law that prohibits the filing and the initiation and the pursuit of frivolous litigation, an exception to that be applied. She says it goes without saying that in the abstract, ensuring that only constitutionally qualified candidates can seek to hold the highest office in the country, particularly when the disqualification sought is based on allegations of insurrection against the very government over which the candidate seeks to preside, seeks to enforce an important right which confers a significant benefit to the public. That, all the things said by the district court judge in Colorado. Her name's Sarah Wallace, once again. A trial on that lawsuit, an actual trial, is scheduled to begin at the end of this month. And though the litigation will continue, the court is going to be focusing in particular, the first time in our nation, really wrestling with this issue of whether or not the 14th Amendment prohibits, at least in the state of Colorado, from Donald Trump's name appearing on the ballot. We'll keep monitoring that as we will in other cases around the country. The second kind of lawsuit that is potentially out there is this. It goes back to the issue of the self-executing nature, arguably, of the 14th Amendment. Many people say that you don't need lawsuits like this, declaring, in fact, that the 14th Amendment means what it says and says what it means. You can simply have people like secretaries of state, local clerks making the decision not to include Donald Trump's name on the ballot. And if they make that decision, again, self-executing as an independent decision, not coming out necessarily of a judicial ruling of the sort that presumably will come from Colorado, these other places around the country, that action in of itself will almost certainly prompt the second kind of lawsuit, which is a challenge to that decision, seeking to have the decision to keep Donald Trump off the ballot, having that reversed, having a judge come in and say, no, the 14th Amendment does not, in fact, require that decision be made in the way that the local appointed or elected official has made that decision. And that, of course, because, as we know from other cases, including one pending before the Supreme Court just this previous term, we know that it's the states, it's not the federal government, it's the states who make these decisions about the terms and conditions and the trappings of elections. That's all done by state officials. Again, so if a state official comes forward and says, you know what, I believe that the 14th Amendment is self-executing, I believe that the former president engaged in insurrection related to January 6th and other matters, both before and after that, and for that reason, I'm going to keep his name off the ballot. That could also prompt many, many kinds of lawsuits, challenging that decision, seeking to enjoin that official from doing what she or he is proposing to do. So a lot of litigation coming up down the road. Many of you asked also about precedent. And again, we haven't had a lot of any opportunity until this recent time to understand what the 14th Amendment really means. The Supreme Court has never weighed in on it. We know, again, in the wake of the Civil War, that it was viewed as self-executing. Why? Because it was fairly clear who the insurrectionists were, those people who advanced the position of the Confederacy. Those folks were identified fairly clearly as having taken an oath of office previously and now violated that oath. It was self-executing at that time. However, we do have some precedent fairly recently, not in front of the Supreme Court, not in front of appeals courts, but we know that a federal district court judge in New Mexico, and we talked about this previously, barred Otero County Commissioner and a Cowboys for Trump founder, Coey Griffin, that's his name, citing this clause in the 14th Amendment. This federal judge in Mexico, and invoking the 14th Amendment, prevented Griffin from serving in a capacity, a state capacity. He had previously convicted of a misdemeanor trespass charge brought by the federal government, again, in the U.S. District Court in Washington, D.C. And the federal judge in the case in New Mexico, found that that was sufficient to support a finding that he had engaged, that is, Coey Griffin, had engaged in insurrection that kept him off the ballot. It was the first time in 150 years that provision had been used affirmatively to disqualify somebody, an official, and the first time that a court had ruled that the events of January 6th were in fact an insurrection. Coey Griffin had been arrested on January 8th of 2021. Federal misdemeanor charges, as I just indicated, trespassing related to the January 6th insurrection. He was convicted of that charge in March 22nd, sentenced on June 17th, 14 days, time served, and ordered to pay restitution of $500, a $3,000 fine, and complete some community service. He was kept off the ballot of the commissioner's position there in Otero County by virtue of an invocation of the 14th Amendment by a federal judge who said the 14th Amendment prohibits someone who engages in insurrection from appearing on the ballot and certainly serving in that capacity. So we know that there's at least that precedent out there for doing this. We will continue to monitor not only your questions and comments about this, taking those all the time as these cases move forward in both categories, both those seeking declaratory judgment that the 14th Amendment does prohibit the former president from appearing on the ballot, and those that may come if indeed a state official says, I'm keeping Donald Trump's name off the ballot. Certainly the Trump team of lawyers, Donald Trump will challenge those decisions again in court, arguing that the 14th Amendment does not in fact prohibit him from serving in that capacity. The presidency does not in fact prohibit him from appearing on the ballots of the particular states in which officials may make that decision. So lots of fascinating civics issues here this morning. We appreciate very much your 14th Amendment questions and comments of this past week, and we'll talk more about those cases as they proceed apace in the weeks and months ahead, knowing that there need to be some resolutions of these issues in the coming months before the 2024 election and even the 2024 primaries coming up in the early part of the coming year. We also spent some time at the end of the last broadcast talking about another aspect, likewise, of the January 6th insurrection, the attempt to undermine votes of Americans in Wisconsin, but also in other states around the country. We know about those facts very well. We talked last week about the request, the entreaty by our governor, Tony Evers, saying that somebody should be held accountable. There has to be accountability, Tony Evers said, when it came to these individuals who made the decision on January 14th of 2020 to sit down in our Wisconsin Capitol and execute these documents, purporting to be appropriate electors from the state of Wisconsin, purporting to be electors who were supporting the presidency, the candidacy of Donald Trump, and purporting to put themselves in the position of the actual electors who are meeting down the hall to execute the actual, real documents at that time going off to Washington, D.C. And so we talked last week about the particular events and circumstances of those events on December 14th of 2020, right here in the state of Wisconsin. Again, an awful lot of argument, an awful lot of discussion about whether or not the electors here in the state of Wisconsin, 10 individuals who did that, who purported to represent themselves as actual electors when in fact they were not only preparing these documents, but sending them off to Washington, D.C., the archives, and to the Congress of the United States of America to be counted as actual votes. They maintain, of course, in the event that the actual electors from Wisconsin, presumably from other states as well, were found to be not the case. None of that happened, of course, and we know what happened on January 6th after the attempted coup, after the attempted insurrection there in Washington, D.C. The slate of electors, including the proper electors from Wisconsin, were counted by the vice president, by the Speaker of the House of Representatives. But along the way, the question remains, did those people who attempted to undermine, to overthrow the voters here in the state of Wisconsin, the proper electoral count, should they be charged with violations of state law or federal law? And we know as well from our previous discussions that there have been some precedent out there already. We know in the state of Michigan, across Lake Michigan, in the state of Michigan, the Attorney General there, her name is Dana Nessel, has in fact brought state charges against the fake electors in that state who did almost precisely what the fake electors here in the state of Wisconsin did. And she has brought those felony charges against those individuals who engage in that kind of conduct there. That case proceeding to trial. We know as well that in the omnibus indictment that's returned by the indicting grand jury in Fulton County there in Georgia, the case now overseen now in the trial court in Fulton County, there in the state court in Georgia, that Fani Willis has also charged a number of the fake state electors there too. Same kinds of things with attempting to undermine the proper votes, the electoral college votes being presented to the Congress properly by purporting to be in this capacity when in fact their positions were fraudulent. She's brought those charges as well. And those are proceeding apace. And the question is, what about the other states, also the so-called swing states, including cases involving the Wisconsin electors? And we chatted last time about the fact that there is a statutory basis for bringing those criminal charges here in the state of Wisconsin. We identified a number of those, among other things, exercising powers as if legally constituted, assuming to act as a public officer, all kinds of things under Wisconsin law that could be brought against those fake electors, including attempts to be parties of a crime, attempt to commit any of those offenses also under Wisconsin statute. So some of you have appropriately sent to me questions and comments about the issues that I began to discuss last week. I'm going to go into them a little bit more detail here. What about the legitimacy of state prosecutions in Michigan, in Georgia, potentially here in the state of Wisconsin, when we know as well that Jack Smith, who is the special counsel handling the federal case involving January 6th. He has brought this singular indictment already, charging the defendant, Donald Trump, with violations of the federal law, 4 counts in particular, attempting to undermine the election. We also know that the Department of Justice is similarly looking at fake electors around the nation, presumably in Michigan, presumably in Georgia, and presumably here in the state of Wisconsin. Lisa Monaco, the Deputy Attorney General, a long time ago said that the Department of Justice is looking at those matters as well. Now, it may well be that Jack Smith will at some point indict more cases, almost certainly will do so. We have talked at great length about the unindicted co-conspirators identified in that federal indictment. Jack Smith will also presumably, through the grand jury process, indict those individuals as well. There may be yet a third tranche of defendants out there similarly indicted by a grand jury for their involvement in January 6th. And there might be a third or fourth tranche of defendants, including fake electors around the country. And so those people are plainly already on files and plainly on lists, not only in the states in which they committed those state crimes, but presumably have already gotten the attention of the federal government as well. So that's where we stand right now. And what about the fake electors here in the state of Wisconsin? Some people have questioned whether state prosecutions of these fake electors here in the state of Wisconsin and other states are appropriate, whether they're necessary, even desirable, especially, again, given this reporting that the federal government is also looking at the same kind of conduct, investigating the scheme to undermine the election federally, and the tendrils that go back into the states, including the state of Wisconsin. That scheme, of course, involves multiple players, but it also involves, according to all the official reporting out there, the reporting reliable, involving these fake electors as a part of the overall scheme to undermine the election of Joe Biden and to establish that Donald Trump should, in fact, have been the president of the United States of America. Some comments about that, which I began to talk about last week. Appreciate very much your thoughts and questions articulated in the past week about whether or not there's need for so-called parallel proceedings between Wisconsin and a federal tribunal at some point, whether that's appropriate, desirable, necessary. When we come back after the break, I'm going to talk more about those potential state law violations and the appropriateness of going ahead with those, even if there is a federal charge or a set of federal charges down the road, and the reasons why there are good social policy reasons for doing both. Stay with us for that discussion right after this break here on Morning Cannolis. We are back here on Morning Cannolis talking about the policy reasons, the strategic reasons, the rule of law reasons for charging here in the state of Wisconsin the 10 fake electors who attempted to undermine the election here in the state of Wisconsin and around the nation, talking about the potential for state law violations that we talked about previously, those giving rise to charges against those individuals, giving the state courts jurisdiction here. The state courts do, in fact, an important role to play under these kinds of circumstances, especially when under these kinds of facts, these kinds of events, those investigations and the facts upon which the charges could be built could prioritize different actors, levels of prosecution, all sorts of things that can be vindicated in the state system. The federal system simply does not. State prosecutors might be more inclined to focus on some local offenders, which plainly are identified among the fake electors here. Federal counterparts, including Jack Smith, we don't know exactly what he's going to do, might target other national players. He's already done at least that when it comes to the indictment against Donald Trump. He's going to identify other players out there. This two-pronged approach, number one, is not at all illegal. There is nothing strategically inappropriate about it. In fact, it happens all the time when it comes to parallel or state and federal proceedings that are proceeding forward in the same path, if you will. Adopting this two-pronged approach, if you will, actually serves to not only advance the rule of law here in the state of Wisconsin, but also does some other important things when it comes to supporting the actual federal prosecution down the road. One of the things that can happen, we see this as well in prosecutions around the country. If indeed there's a state prosecution, it is entirely possible that some of those defendants identified in a state prosecution could agree to cooperate with the government, the state government, the federal government, in identifying what they know about other people also involved. And so there's actually an advantage to charging state actors here in the state of Wisconsin for their state violations of law that might be helpful not only in future state prosecutions, but especially as Jack Smith continues down his long list of defendants who might potentially be charged in the federal system. Plainly, the Attorney General in the state of Wisconsin has the not only statutory authority to do this, he's got the prosecution authority to do this. We know as well that these particular state interests, the vindicating of the state interests that I've talked about, can't be done by anyone else aside from the principal law enforcement authority here in the state of Wisconsin. Michigan can't do it. Fani Willis in the state of Georgia can't do it. And yes, Jack Smith can do it on the federal level, but again, there's some significant reason to prosecute state actors for their violations here in state law, vindicating the state violations that have been perpetrated by those individuals. Nothing about parallel proceedings is prevented by the law. Nothing about it is presented by a strategically wise approach to these issues, addressing all those people who attempted to engage in the undermining of our election back in 2020, 2021 in particular. All those things supported by the law and supported by the strategy that is undertaken routinely when federal and state elections are addressed, and the interests of state officials, the interests of state citizens in ensuring that their laws are enforced are also enforced at the federal level. We know as well from our last week discussion that as a part of it's an interesting, more than just an interesting footnote, that in March of 2022, in connection with the review by the Wisconsin Election Commission of a complaint about this very issue, that is, this administrative body having before it the decision about whether or not there had been a violation of state elections law. We know at that time that the Department of Justice, under the auspices of our President Attorney General, had concluded that the fake electors weren't trying to fool the Senate, the United States Senate, but instead were legitimately trying to preserve Donald Trump's legal standing. That was a ruling and an opinion issued by our Attorney General back in March of 2022. A lot of that subject to an awful lot of questioning given the facts and circumstances of what happened on December 14th of 2020. But that opinion, again presented to the Elections Commission at that time, said this: the memorandum concludes that the complaint that is against the fake electors does not raise a reasonable suspicion that the respondents violated Wisconsin law. They cast their votes even though the canvass did not reflect a Trump victor in order to preserve the opportunity for votes to be counted if a court challenge found that Trump received the majority of votes. That analysis, again, from the Attorney General back in March of 20, indicating that at least in connection with state election laws, it was his position that they had violated nothing. And that may be a significant hurdle, a significant burden when it comes to filing state prosecutions under these other theories that I've identified. It is out there, is a part of the decision-making process coming out of our Attorney General's office, again, about 18 months or so ago. All of this, however, not prevented from going ahead and filing those state prosecutions against those individuals. It is a matter for the Attorney General to take up and do on behalf of vindicating the interests of people in the state of Wisconsin for these violations of state law. All of that, again, appreciating tremendously your interest in that particular issue, 14th Amendment, and also, again, this morning, state electors in the state of Wisconsin and throughout our nation. I promised at the start that we would also talk in this hour and into next hour about a variety of other things having to do with many of the lawsuits, criminal and civil, pending against the former president. We're going to do that. We're going to begin now with some of that, continue that into our second hour, and then spend a fair amount of time talking about the Supreme Court into our second hour here on Morning Cannolis. This past week, we know that the civil lawsuit pending against the former president, members of his family, members of the Trump Organization, continued in the Manhattan State Court. This is a civil proceeding. It is not a criminal proceeding. Brought by who? Brought by the Attorney General of the state of New York. Her name is Letitia James. She has brought charges, again, in a way that underscores the significant role of state attorneys general in vindicating state interests, the state legitimate interest in ensuring that the state laws are supported and that people who violate them are brought to justice. She brought this lawsuit seeking about $250 million in damages against the Trump Organization, prohibiting, part of her request, the Trump individuals, and including Donald Trump himself, his sons, from ever again participating in any sort of corporate entity when she's got responsibility for oversight and supervision. And also seeking other remedies that are before a fellow named Justice or Judge Engoron, we've talked about at great length in the past. That particular judge, or justice as they're called in New York, has already found that the fraud took place. He already found that Letitia James had presented on documents and in paper documents in the summary judgment mode the sufficiency of support to find that fraud had taken place. When we come back after the top of the hour, we're going to talk about what happened in the continuing case in front of Judge or Justice Engoron just this past week, testimony and anticipated testimony in the future weeks. Stay with us for that second hour here on Morning Cannolis.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning. This is the second hour of Morning Cannolis on this Saturday, October 14th, 2023. Thank you for joining me in this, our 67th broadcast. I'm joined in the studios here in Waukesha by my wonderful producer, Anya, and together we're taking your phone calls at 844-967-2789. We'll also take your text messages about things we're chatting about during the course of this next hour, focusing in particular upon some of the litigation pending in the courts of America, and then also talking about the United States Supreme Court. As always, we're talking about the most important issues, the stories in law, in government, and the aspiration for justice in America, and yes, indeed, around the world as well. Thank you for joining me this morning. Thank you, as always, for your thoughtful comments and questions about the subject matters on our syllabus. That includes some summaries in the next couple of segments of what's going on in some of the courts pending around the court cases pending in our nation's courts. Let's talk in particular about this civil case pending in the Manhattan State Court. This, again, is the litigation brought by the Attorney General of the state of New York, Letitia James, charging that Donald Trump and his family members, his corporation, engaged in valuation misrepresentations and fraud when it came to assessing and reporting on the values of various properties, implicating state law. That's the predicate for the Attorney General's prosecution. A lot of this, again, focusing upon what actually happened inside of the Trump organization at the time of these representations. This past week, Alan Weisselberg, again, the CFO, previously convicted in the federal court for similar violations of those involved bookkeeping, misrepresentations, and fraud. He's already a convicted felon. He appeared in this case to talk about the circumstances under which various representations were made about the valuations of these properties. And he took the stand on Tuesday, day six of this financial fraud trial, and basically testified that Donald Trump had grossly exaggerated the size of his penthouse apartment on financial statements made to banks and insurers. So Weisselberg was fairly clear about that particular aspect of this. In particular, in October of 1994, according to Weisselberg, Trump signed a document certifying the triplex apartment was 10,996 square feet. But in 2012, many years later, he listed the apartment at 30,000 square feet. And that, supports the charges brought by the prosecutors in this particular case. So Weisselberg, again, called as a prosecution witness to support this notion that the misrepresentations have been made. However, along the way, of course, Weisselberg attempting to limit the damage, if you will, to Donald Trump along the way. He said this. He said, "I never even thought about the apartment." He added, "It was not something that was more important to me when looking at $6.5 billion of net worth." Again, indicating that while this happened, the overall focus of his was upon the overall management of the company at that time. Alan Weisselberg's testimony, important again in establishing the mechanisms through which this fraud was perpetrated. Alan Weisselberg in a tough position because he plainly wants to have it both ways, if you will, wants to support in some ways his former boss, his continuing boss, which is a part of the bias that he has. He remains on the Trump payroll even to this day, but also being called as a prosecution witness and knows that if he lies, if he provides information under oath that is not true, he can be subject to a prosecution, a state prosecution for perjury as well. And so Alan Weisselberg's testimony important to this case as it goes forward. There was other big news that was going to happen this coming week. We learned just last night about a change in some witness testimony that was going to be scheduled for this coming week. We know as well that Michael Cohen, the former president's fixer and longtime attorney, was going to testify in that same trial about the same kinds of things. According to prosecutors, Michael Cohen was going to come forward and talk once again about the ways in which the Trump organization works, again, focusing upon the valuations of these properties. And Cohen was slated to testify on Tuesday. Late last night, he indicated because of a medical issue that would have to be postponed. But he is expected to be another key witness along with Weisselberg in this case. Again, important to establish inside the corporation what people understood, and in particular, what role did Donald Trump play in putting together these evaluations, in knowing about them, in sanctioning them. Again, Michael Cohen going to be testifying at some point down the road in that important case coming out of New York State, the New York fraud case. Again, not a criminal case, but a civil case. We know as well that there was some significant goings-on in the so-called classified documents case. This is a federal case. This is one brought by federal prosecutors, Jack Smith in particular, the special counsel appointed by the Attorney General. This is going on in the state of Florida, a federal court there, being presided over by Judge Eileen Cannon, prosecuted once again by Jack Smith's attorneys there, charging not only Donald Trump with violations of classified document laws in the system, charging him with taking documents to which he was not entitled, using them, engaging in other criminal conduct, that case pending once again in Florida, a federal case, but also charging Trump valet, his name is Walt Nauta, N-A-U-T-A, and a property manager named Carlos de Oliveira, with efforts to undermine justice, to compromise the safety and security of the videotapes that presumably will be presented during the course of that trial. During the course of recent proceedings, just this past week, Eileen Cannon entertaining some arguments from Jack Smith, from the prosecutors in this case, about potential conflicts of interest brought by, again, the government against the lawyers who are seeking to represent Nauta in particular. The attorney there, his name is Stanley Woodward. And the problem that the prosecutors identified, this so-called conflict of interest, is that Stanley Woodward previously represented many other people also involved in the investigation of this case, some of whom are presumably now cooperating with the government in this matter. Among those, a fellow named Yusil Taveras, and you may recall from our previous discussions that Yusil Taveras is the IT fellow. He's the one who was approached by de Oliveira, presumably through the instruction of Nauta, presumably through the instruction of Donald Trump, to seize and destroy the tapes of the movements of these documents in and around the Mar-a-Lago facility. And the concern, of course, is that if Stanley Woodward, again, previously representing Yusil Taveras, who is cooperating with the government, Woodward now representing one of the defendants, Walt Nauta in this case, that's a conflict of interest. Why? Because at some point, almost certainly, Stanley Woodward acquired, through the course of his attorney-client relationship with Yusil Taveras, some information about what he knows, and will have an opportunity, presumably, during the course of the trial, in which he's now representing a defendant, to question his former client on the stand, Yusil, and these other people also providing information to a trial jury. The judge, Eileen Cannon, entertaining argument, again, from the government, basically seeking to disqualify Stanley Woodward from the continuing representation of Walt Nauta based upon his prior representation of people, including the IT fellow, Yusil Taveras, who are now cooperating, providing this information not only to the grand jury, but also presumably to a trial jury there in South Florida. The judge, somewhat frustrated by the length of these conversations, the arguments being engaged in the federal court, not yet making a decision on that particular conflict of interest claim, but also going to impact who is going to be representing people in that case. Major case developments coming out of South Florida just this past week. And then we also know some important issues coming out of the case involving Georgia. And in particular, this is the allegation, the indictment brought by Fani Willis, to which I made reference previously. Fani Willis, again, charging 19 different defendants, including Donald Trump, including many, many other actors, for their attempts
to violate, and their actual violations of Georgia law. That is, again, vindicating the interests of Georgia residents and Georgia citizens in ensuring that their votes are counted properly. This past week, and a part of her response to a request by a fellow named Jim Jordan. Jim Jordan, who right now is the present nominee to be the next Speaker of the House of Representatives in his capacity as the chair of the House Judiciary Committee. Jim Jordan has previously requested from Fani Willis information about the conduct of the investigation there in Georgia, about the conduct of the prosecution, plainly trying to push back on what's going on there in Georgia. And in response to those requests from Jim Jordan, again, right now, not only a congressman, but also perhaps the next Speaker of the House, depending upon what the United States Congress, the House of Representatives, does, presumably in the days just ahead, in responding to the request by Jim Jordan for information about her state prosecution, again, this coming out of the United States Congress, the House Judiciary Committee, a scathing response, if you will, from Fani Willis to Jim Jordan, request for documents and other materials about this investigation. Fani Willis reiterating, as she has done before, the reasons for refusing to comply with that request. Here's what she said. She said, "A charitable explanation of your correspondence is that you are ignorant of the United States laws and the Georgia Constitution and its code." That's what Fani Willis is saying to Jim Jordan. A more troubling explanation, she said, is that you are abusing your authority as chairman of the Committee of the Judiciary to attempt to obstruct and interfere with a Georgia criminal prosecution. Those are strong words coming from a prosecutor. Again, statements not only pushing back against his request for this information, but telling him that he may in fact be in violation of Georgia law and even the Constitution of the United States of America. Previously, Jim Jordan had accused Fani Willis of targeting inappropriate federal officials for political reasons, doing other things to undermine her oath of office, not in pursuit of her oath of office. All of that, the subject of a huge amount of pushback just this past week coming out of Georgia. All of those things happening out of that state criminal prosecution there as well. And we also know that coming out of the January 6th criminal prosecution, some important issues related to likely defenses coming up in that case. When we come back after this break, we're going to talk about Jack Smith's attempt to identify exactly what the nature of the defense is going to be and whether or not an advice of counsel defense will be raised by the defendants in that case. Stay with us for that continuing discussion right after this break.
It's 48
And we are back here in Morning Cannolis doing some updates about the major cases pending in state and federal courts involving the former president and others, not only in connection with January 6th, but also classified documents, attempts to defraud in the state of New York, and now turning to this major case. It was brought again by a federal grand jury in the District of Columbia against Donald Trump, singular defendant to date in that case. As indicated before in connection with our discussion about the fake electors this morning, highly likely that at some point Jack Smith will either supersede in that particular case or bring entirely new indictments, again, through the grand jury process against some of the unindicted co-conspirators in that case, 6 of them in particular, probably against other people, and maybe down the road against fake electors as well. Again, as I said before, not compromising in any way a parallel or more immediate state prosecution of those fake electors here in the state of Wisconsin. In that January 6th federal criminal prosecution, now pending in front of District Court Judge Tanya Chutkan in the District of Columbia, some other activity also important to the future defense of that case by the defendant, Donald Trump. And in particular, lawyers on the team assembled by Jack Smith to charge and to prosecute this case against Donald Trump submitted a memorandum this past week requesting that Judge Chutkan require Donald Trump through his attorneys to declare whether he intends to put forth a so-called advice of counsel defense when the case goes to trial. And you might think, well, gee, how is that possible? And the answer is there are all sorts of reasons why in this pretrial setting that the parties have rights to understand what the other side will be doing. Among the most important rights, of course, defense has the right to virtually all the discovery that the government has assembled during the course of the investigation. That's called Brady material, Jenks material, all kinds of names for this discovery. Basically, the government turns over all kinds of information. And we're in that period right now where the parties attempt to winnow and sift through all of that and make requests of the other side about what's going to happen next. There can be motions to dismiss, motions to suppress. Among those, Jack Smith, again, in response to what he has heard out there about a possible defense, an advice of counsel defense, Jack Smith asking that the court order that Donald Trump's attorneys describe with particularity whether or not their client, Donald Trump, intends to rely on this advice of counsel defense. And what does that defense partake of? Basically, it says this, that I was not criminally responsible. I didn't have the intent to engage in the particular crime with which I'm charged because I did what? I relied upon the advice, the counsel, the direction given me by my attorney. My attorney told me this was okay, and for that reason, I decided to do this kind of conduct. But that absolves me of the criminal responsibility to engage in the crime as it is charged. It is a legitimate defense that is out there. It's fairly narrow in its application if you think about it, just because it happens to apply most often when there is some arcane or very, very specific kinds of laws that only maybe attorneys would know about, tax laws, for example, corporate laws. Typically, advice of counsel will not come into play when, in fact, one is charged with something like bank robbery or drug dealing, something large and broad, where everyone knows it's in violation of the law to do those kinds of things. But it is available. And in particular here, again, Jack Smith's team is asking the judge to ask and to require the Trump attorneys to declare with specificity whether or not this advice of counsel defense will be raised by Donald Trump in response to the indictment against him. And in particular, in the filing, prosecutors said that if Trump uses that defense at trial, it would then allow them, that is the government prosecutors, to seek additional testimony from about 25 people. Some 25 other witnesses are out there, including significantly some members of Donald Trump's family who withheld information, communications, and documents based on assertions of attorney-client privilege. And that's all in the pleading, again, filed this past week. This is the reason why Jack Smith wants this information, because it opens up the door to get testimony from people who've otherwise said, I have got an attorney-client relationship. That relationship cannot be breached. That privilege cannot be breached. And for that reason, we cannot testify. Well, Jack Smith argues, if you're going to raise the advice of counsel defense, that is, that my attorney told me to do that, you are effectively waiving that privilege. You're basically saying, I'm going to tell you about what my attorney said to me during the course of our discussions, our negotiations about that. And you've basically stripped yourself of that advice, that attorney-client privilege, opening up the door to all the rest of this. That's the legal theory. That's the reason why this is so very important. Using this defense would invalidate, effectively, those claims of attorney-client privilege by these 25 or more witnesses who have raised this already. And so Jack Smith, again, seeking a directive from the district court judge to the attorneys representing Donald Trump to state affirmatively whether or not Donald Trump is going to be saying that he relied upon the advice of counsel in engaging in any of the activities that he's charged with in that 4-count indictment against him. Again, all those kinds of things that we have talked about at great length before. A significant move this past week because it's going to define in major ways not only the conduct of these pretrial proceedings, but also who's going to testify at trial. And so the Judge Chutkan, obviously receiving from the Trump team a response to this, pushing back on this requirement. But nonetheless, she is going to decide at some point, Tanya Chutkan will, about whether or not she is going to issue an order directing the provision of this information to the prosecutors as a part of this pretrial process. Again, she is presiding over this federal case pending in the District of Columbia. We know Eileen Cannon, also now presented by this unrelated issue involving a conflict of interest in the Mar-a-Lago documents case
That one also federal in nature, but pending in Florida. Lots of things going on in the federal courts just this past week, the state courts as well. All of those as a part of our rule of law updates here on Morning Cannolis. When we come back, finally, in our last two segments, we're going to talk about the United States Supreme Court, things on its docket just this past week, important things to know as we understand about what's going on at our highest court. Stay with us for that engagement.
Oh, Maggie, I couldn't have tried anymore. You led me away from home just to save you from being alone. You stole my soul, and that's a pain I can do.
At you. And if you miss a show or
And we are back here on Morning Cannolis. Thank you for your continuing involvement here with our discussion of law and government and the aspiration for justice in America. Always taking your phone calls at 844-967-2789. Also soliciting your texts, your written comments, questions about the things that we're chatting about. In these last couple of segments, we're going to chat about the United States Supreme Court, things on its docket, things about which all of us should be attentive because, as we know well, the United States Supreme Court making major decisions, as it has always done, that affect who we are, how we live our lives, and ways we conduct our business, our commerce, our transportation, education, healthcare, privacy rights, all kinds of things out there that implicate the ways in which we deal with each other and have our lives here in the United States of America. This past week, the United States Supreme Court added about 10 to 12 more cases on its docket. Last week, we reported that the United States Supreme Court had in its docket somewhere around 23, 24 cases. This week it jumped to 36. And again, probably going to settle somewhere around 60 or so by the time that all of this is done. Among other things, among other cases that it added, just this past week was a major additional case having to do with this battle over what's called the Chevron Doctrine. The Chevron Doctrine, we're going to be chatting a lot about that in the future. That Chevron Doctrine is a long-standing judicial principle that basically says that courts, in deciding whether or not the actions of administrative agencies are legitimate or not, whether they're legal, lawful or not, should basically rely upon the decisions and the judgments of administrative agencies, their interpretations of the law in issues where the Congress, under that law, was silent or is fairly ambiguous, was not clear in terms of what should happen. Courts have traditionally said, we will defer to what the agencies say, and that's called the Chevron Doctrine, coming out of a major Supreme Court case. Major cases now pending in this term of whether or not the Chevron Doctrine should be not only dismantled, but completely discarded, giving judges, federal judges, great authority when it comes to, if you will, second-guessing the expertise, the agency experience in making decisions about things in front of them on a regular basis. And so we know that the United States Supreme Court has previously granted cert. It's already got on its document granted this writ of certiorari to hear a case called Loper Bright Enterprises versus Raimondo. And that was concerning the company's fight against a regulation that requires Loper Bright, that is the company, to pay for federal observers aboard their boats. It's a maritime case. And while that particular rule is very important, along the way, the owners of that corporation have asked the court to get rid of the Chevron Doctrine, basically say that what the maritime federal agency has said about payment for these monitors on board should be discarded, and that the deference that's previously been given to those decisions should be gotten rid of. A lower court upheld the regulation under the Chevron Doctrine, but the appeals court basically overturned that decision. So that all before the United States Supreme Court, already pending just this past week, and a new case indicating once again that the Supreme Court highly likely, very interested in this and highly likely to overturn Chevron, which is a huge movement when it comes to federal jurisprudence, decided to grant cert in a new case. This one's called Relentless versus Department of Commerce. It originates from the same fishing boat observer regulation and does, in fact, raise the same kinds of issues. The Chevron issue
That case also now pending before the United States Supreme Court. Interestingly, in connection with ethics before the Supreme Court, Ketanji Brown Jackson had previously been engaged in some decision-making with respect to the case, again, involving Raimondo or Loper Bright Enterprises. In this new case, in which she was not involved, she is not going to be recused. And again, it underscores the importance of justices making these decisions about cases in which you don't want the appearance of impropriety or actual impropriety in reaching decisions. Ketanji Brown Jackson getting it just right, saying, you know what? With respect to the earlier case already pending, this Loper Bright Enterprises case, I'm going to recuse myself because of my previous involvement. The new case, the Relentless case, not involved in that one, so she will join 8 other members of the court in deciding that case, both of them obviously focusing on the same issue. In an unusual move just this past week, the Supreme Court has sped up its consideration of these petitions, enabling the justices now to take up these cases sooner than in the normal timeline. And for that reason, this Chevron issue going to loom large, maybe going to be one of the major decisions pending before the United States Supreme Court in this term. We'll get back to that as well during the course of our discussion about the United States Supreme Court. The United States Supreme Court also indicating will be addressing a major case involving bankruptcy reorganization and whether or not the protections of the bankruptcy court involving fraudulent claims tied to asbestos exposure. That case also now brought into the increasing docket, now up to 36 cases pending before the Supreme Court as of this morning. We know as well, my reference to ethics already, the ethics issue continues to loom large in front of the Supreme Court. No change, regrettably, in the status of that. And what is the status? It's basically stalemate. We know that the United States Senate, coming out of the Senate Judiciary Committee, this is the Senate Judiciary Committee, headed by Dick Durbin, the senior senator from Illinois. Dick Durbin, successful in getting reported out, marked up from the Senate Judiciary Committee, some legislation that would impose upon the Supreme Court a set of rules and regulations, some enforcement mechanisms as well. Also supported, authored by a fellow named Sheldon Whitehouse, another senator there advocating for some ethics rules and regulations for the Supreme Court. That passed out of committee, but obviously going nowhere in the Senate. So congressional efforts to address this problem still not moving forward in any way. Some increasing indications that the court itself, including statements by Elena Kagan recently, that the court continues to work internally on its own decision about whether or not a code of ethics should be imposed. But to date, the Chief Justice not doing any of that. And to date, we do not have a code of ethics of the sort that applies equally to district court judges and to appeals court judges around the country. That code of ethics, which could be applied to the Supreme Court as well, not applying them to this date, again, because of no legislative activity, and most importantly, where this should happen, the self-imposition by the Supreme Court of its own set of ethics rules and regulations. That hasn't happened. And because of that, the court still without a code of ethics, even as it undertakes these very important cases before it. So what cases are pending in front of the United States Supreme Court right now? Last week, we talked about 3 of them involving this case involving Pulsifer. This is the case in which a question about sentencing having to do with the interpretation of the word and or, linguistics in front of the Supreme Court. That argued a couple of weeks ago. This CFPB case in which the Supreme Court is wrestling with whether or not the Consumer Financial Protection Bureau is legitimately constituted, almost certainly rejecting notions that that particular agency is unconstitutional. And third, this case involving Atchison Hotels, this very interesting case involving the Americans with Disabilities Act, whether a tester who had no intention of staying at the hotel, but testing the applicability of the ADA to statements made by the Atchison Hotels and its online advertisements are consistent with the ADA. That issue also in front of the Supreme Court, obviously coming up for decision down the road. This past week, 3 additional arguments in front of the Supreme Court. Let's talk about those right now. On Wednesday, perhaps one of the other major cases being decided by the Supreme Court in this term, a case called Alexander versus South Carolina State Conference of the NAACP. Yes, indeed. It's another voting rights case. It's another gerrymandering case. And in particular, this case concerns the interplay between politics and race. And that's why it's somewhat distinguished between the merits of this case and the Alabama case we talked about at great length in the past. That case from the previous term, you will well recall, in which the Supreme Court and a panel of the Fifth Circuit has told the Alabama legislature that they need to go back and redo their gerrymandered lines. Now a cartographer and a special master redrawing those lines for the legislature there because it did not do it on its own. This is another case, this one coming out of South Carolina, raising the same issues, but slightly different as well. This case, again, Alexander versus South Carolina, NAACP, similar to Alabama, again, but also involving some distinct legal principles. And what are those? Well, the Alabama case, again, involved the Voting Rights Act, that landmark civil rights statute that we talk about routinely here. And the one from South Carolina focuses again on voting rights, but also on the Constitution's Equal Protection Clause. At the start of the first hour here, we talked about that under the 14th Amendment, the ways in which we traditionally invoke and apply the 14th Amendment to ensure equal protection to all people in the United States of America. The two cases, again, arguably tug in some different directions, and we'll see how the court reconciles them, even as the court just this past week was much more skeptical about whether or not the legislature, again, in this case involving South Carolina, had acted improperly under the Equal Protection Clause. And how did this case come about? Well, a unanimous three-judge panel of the federal district court in South Carolina, Columbia, South Carolina, the state capital, had ruled way back in January that the first congressional district there in the state of South Carolina, which was drawn again after the 2020 census, violated the Constitution by making race the predominant factor. And that's the key to all of this, whether this is race or politics. And Justice Elena Kagan, just this past week, said that ruling was sound, even though the lawmakers were free to achieve their political goals directly by using data on partisan voting. And specifically, she said this. She said what they could not do, according to Elena Kagan, was achieve those goals indirectly by using data on race. Data on race. She told a lawyer for the lawmakers appearing in front of her that the evidence showed that you were using race as a proxy for politics. And she added that the practice of this practice was fairly curious. Why would map makers, she said, in general and in this case, use race as a proxy to do partisan gerrymandering now that you could just like do partisan gerrymandering? That was what she was asking. And so the question again is this interplay between race, and data used in connection with political gerrymandering. Justice across the ideological spectrum, putting Justice Kagan's comments to one side, agreed, of course, that the Supreme Court can only overturn the lower court's rulings if they rule the lower court was clearly erroneous. And that's the legal status, the legal standard that they're addressing in deciding whether or not what the legislature did was proper or not, and in particular, whether or not the lower court ruling that indeed these cases violated the Constitution by making race a prominent factor, whether that was supported by the evidence in the case. And the Supreme Court, again, not going to overturn this unless that lower court finding was clearly erroneous. And again, several conservative justices indicating that they were prepared to rule that the lower court had committed a clear error, even with that high standard established in these kinds of cases. Amy Coney Barrett, for example, said the court must also take account of two other factors. This according to the Supreme Court Justice Coney Barrett. She said that the plaintiffs bear an exceedingly high burden when they're trying to disentangle race and politics, and that we give the legislature a presumption of good faith. That coming from Amy Coney Barrett. John Roberts likewise suggested that the administration's position was novel and sort of surprising. Again, the administration supporting the lower court decision here, finding that there had been a violation of law. He said this: "Have you ever supported the plaintiffs in a case in which there was no evidence of any direct discrimination, no alternative map, no oddly shaped districts, and a volume of political data?" And again, all of that a part of the oral argument just this past week. This new House map moved about 62% of black voters in Charleston County from the 1st district in this to the 6th district, and moving the percentage of black voters from one district to another. And that seat was the seat that Representative Jim Clyburn has held for about 30 years. He previously served as the whip, the House whip, major figure in the House of Representatives to this day. Significantly, that move accomplished by the legislature, again overturned by the district court, now an appeal to the Supreme Court, also make that new 1st district a Republican stronghold. And that's why this interplay between race and politics is so important. In November, Nancy Mace, the Republican incumbent, won re-election there by 14 percentage points. Ms. Mace, of course, also a major figure, as we've seen her recently.
And we are back for this, our final segment here in Morning Cannolis this Saturday morning, chatting right before the break about this very significant case. Alexander versus South Carolina State Conference of the NAACP. Looks to be that the Supreme Court, unlike its decision in the Alabama case in the previous term, is in fact going to find that what the legislature did here was permissible, again, based upon some of the tea leaves, some of the comments articulated by the justices in that oral argument just this past week. The justices have described the principal question before it as this: did that district court, again, the district court finding that the legislature had in fact violated the Constitution by drawing these lines, changing the districts there in South Carolina, did the district court clearly err? And again, that's the standard in finding that the legislature used a racial target as a proxy for politics. When the record showed, again, this is according to the Supreme Court's question here, showed that the legislature was aware of race, that race and politics are highly correlated, and the legislature drew districts based upon election data. Again, the issue is somewhat complicated, but nonetheless, identifying for the first time this question about how you sort through the difference between race and racial animus and racial decisions to act based upon race, those that are premised upon politics. Again, the Supreme Court has said that political decisions are not subject to federal review. Racial discrimination, that's different. And when they're intermixed, what do you do in a case like that? And that was before the Supreme Court, that very issue before the court just this past Wednesday. Significantly, as an important footnote to that, just this past week in Texas, a redistricting plan was found to have violated the Voting Rights Act. This coming out of a district court over the Southern District of Texas just yesterday. A political redistricting plan violating the Voting Rights Act. The court said that it denies Black and Latino voters equal opportunity to participate in the political process. The court found in particular there, again, this is a district court, that Galveston County eliminated an existing district that had existed for decades there in Texas, even though Blacks and Latinos comprise about 38% of the total population in the county. There, in fact, you do get reminiscences of the Alabama case. The Commissioner Court is the governing body for Galveston County, again, finding that there had, in fact, been a violation of the law, the Voting Rights Act. In that case, perhaps that one, too, will get to the Supreme Court. More likely falls in the category of the case coming out of Alabama, coming out of the Supreme Court this past term. We've got this new case, however, coming out of South Carolina that is going to be interesting to watch because it raises these new issues about the interplay, again, between politics and race when it comes to decision-making by legislators. A couple of other issues before the Supreme Court. Both of them argued this past Tuesday, one of them having to do with whistleblowers, in particular, whether or not a whistleblower has to prove some level of intent when it comes to a retaliation made by his or her employer. The case involves a fellow named Trevor Murray. He had sued his employer named UBS Securities. It's a broker dealer based in New Jersey, alleging that his employer had terminated his employment
because he reported some alleged fraud, and he came forward, and again, a classic whistleblower situation. Murray claimed that he was targeted for layoffs because he reported this fraud and identifying these illegal efforts by his colleagues to skew or sway some independent research analysis. A jury had awarded him about $600,000 in back pay, about $250,000 in non-economic compensatory damages. And of course, the employer has pursued that. And the question again before the United States Supreme Court is what one does when it comes to what the burden is upon the employee to show actual retaliatory intent. Eugene Scalia, who is representing the employer in this case, and yes, Attorney Scalia, the son of the former Supreme Court Justice, he was also a former Secretary of Labor, who was the attorney, said that Congress did not eliminate a retaliatory intent requirement in the law, and it said that the plaintiff still has to show retaliatory intent as a part of its fundamental presentation before getting to the merits of the case. He said that's fundamental discrimination law. Several justices expressed some skepticism about the employer's argument, and they asked how the retaliatory intent standard is not already accounted for inside the burden shifting that's set forth in law. Justice Ketanji Brown Jackson, for example, said, "What I'm struggling with is trying to understand how causation and intent are different in this world. It seems to me," she said, "that they both get at the same thing." Clarence Thomas, not surprisingly, disagreed with her. It said, "It seems that the substantive statute provides the but-for causation and has an intent requirement." Neil Gorsuch suggested the court could conclude whistleblowers only have to show discriminatory intent, not retaliatory intent, which is what the case is ultimately all about. Gorsuch saying this, he said, "I see discrimination in this statute, and I see whistleblowing activity, and I know there's a causation requirement, but I do not see the retaliation in this statute." Overall, however, the court seemed sympathetic to Murray's argument, and for that reason, we'll see what happens down the road. Again, this issue having to do with what level of intent, retaliatory intent, what is the burden? What is the burden that whistleblowers have in coming forward these days when alleging that they were terminated because of their legitimate activities in identifying criminal activity or other inappropriate activity by their employer? What kind of retaliatory intent does the employer need to show? What is the burden upon the employee to respond to those claims of retaliation by an employee in those kinds of cases, subject to a lot of disagreement among the justices just this past week. And finally, a case also involving something fairly complicated, but having to do with the choice of laws. I will tell you that when I was in law school, one of my favorite classes was choice of law. This case involving that same issue about what kinds of laws do you apply when it comes to different laws in different states. And so this case is called Great Lakes Insurance Company versus Raiders Retreat Realty. And the question, whether or not state or federal law should govern in this case, has to do with the enforceability of something called the Maritime Choice of Law Clauses. And it seems, as does all of this, highly technical, the kinds of things that only lawyers can decide. But here, for example, a foreign insurance company insured a yacht, and that was owned by a Pennsylvania company. And although neither party of the contract is from New York, the insurance contract selected New York law. And the question there is what should apply, federal law, in this case, Pennsylvania or New York law. We'll be discussing those cases and others in future broadcasts here in Morning Cannolis. Join us every Saturday morning for discussion not only of the Supreme Court, but those other major issues in law, in government, and the aspiration for justice in America. Thank you for joining me this morning. Have a good week, everybody.
Everybody